So, in this video, as the title would suggest, we're going to look at a court case that occurred in May 2017, which involved Lady Justice Thirlwall and what could very well be, I would say probably is, Dr. Dewi Evans. The reason the title has a question mark is that I cannot categorically state that this is Dr. Dewi Evans, but it's definitely a case that merits serious consideration and analysis, just because of the names involved, I think. Firstly, I just want to credit this guy. I assume it's a guy. His name begins with Rob. RoboMax1143 for drawing my attention to this case. And he provided some very useful comments, and I've done some further digging and research in preparing this video. So the case in question is this one: FB suing by her mother and litigation friend WAC versus Princess Alexandra Hospital NHS Trust. As you can see, the judgment date is the 12th of May 2017. The case was actually held in March, as I'll show shortly. Now, another fascinating fact about this case is this involves Lady Justice Thirlwall and Lord Justice Jackson. Now, as far as I can tell, this is not the Lord Justice Jackson who wrote to the Letby trial judge James Goss, because we believe that he began working as an appeal court judge in October 2017, and this predates that. So that would have been quite incredible if there was Thirlwall, Jackson, and Evans in the same case. But there is Thirlwall for sure, and it looks very likely that this is Dr. Dewi Evans. But I'll explain what we know and what we... Essentially, the reason we don't know that it's Dr. Dewi Evans for certain is the Christian name of the Dr. Evans that features in the case is never confirmed, and I've tried various avenues of research to confirm it, but it's for me, with my resources, it's essentially impossible. But in this video, I'm going to go over what we do know about this case. So this is the first paragraph of the judgment, the verdict. So I'll just read this out. This is an appeal against an order of JJ dismissing the appellant's claim in negligence against the respondent hospital at the end of a trial on liability. The respondent was the second defendant to the appellant's claim in negligence. There is no appeal against the judge's dismissal of the claim against the first defendant, a GP in a local out-of-hours service. So, just to explain this briefly, this is a medical negligence claim that's being made against an institution, which is, as we saw in the first page here, the Princess Alexandra Hospital. The doctor that appears in this case is a female doctor by the name of Dr. Rushed. There isn't a claim being made against her as such, and she is still a practicing doctor in a different capacity. It's really the hospital that is being called into question. I should say that the original verdict was in favour of the hospital, and this appeal, as we will see, overturns that verdict. So it refers, this case refers to a young infant born in August 2002 who became unwell on the 18th of September. On the evening of 29th of September, she was admitted to this hospital, at the time very ill. On the 1st of October 2003, she was transferred to Great Ormond Street Hospital, where a diagnosis was made of pneumococcal meningitis and multiple brain infarcts. FB recovered, but she had sustained permanent damage to her brain. She has learning difficulties and is profoundly deaf. So I guess my reflection on that would be, this case illustrates how easily, I would assume this is an otherwise stable child. There's no indication this is, obviously it's not a neonate. This infant is, just over a year old, 13 months. It just shows how a little thing can be missed and the consequences can be enormous. So it's not always, these things are not always predictable, but that's not a central aspect of this case or this video. I just wanted to point that out. So here it's noted that the appellant's case was that Dr. Rush was negligent in failing to take an adequate history and failing to conduct an adequate examination. So essentially, the parents have brought this infant into the room with this doctor, and there are problems with this infant, and Dr. Rush should establish what has occurred with this infant and obviously examine this infant. And it's stated here, had she performed other tasks to standard of a competent SHO, she would have been bound to refer FB to the paediatric team. Instead, she discharged her. It was agreed that had FB been referred to the paediatric team, she would have been given antibiotics by 9 am on 29th September. The antibiotics would have prevented the spread of the infection, and FB would not have suffered any injury. The issue at trial, therefore, was breach of duty. The judge found that there was no breach in respect of either history taking or examination. Both conclusions are challenged in 10 grounds of appeal and in a detailed skeleton argument. The oral submissions were directed principally to the conclusion on history taking, but in order properly to consider those submissions, it is necessary to set out the judge's findings of fact and his approach to the standard of care. So that should all be fairly straightforward. Clearly, there's been a horrible incident here where an infant has gone into a hospital and ended up being seriously disabled as a result of what has occurred. And the suggestion is that this doctor, who's not an experienced medic, should have done better, essentially. So the 9th paragraph notes an ambulance was dispatched immediately that arrived at 4:32 am. So it's important to note this is happening very early in the morning. The paramedics recorded, amongst other things, Mum says patient V lethargic, OE patient eyes rolling, not coordinated. So this was deemed critical in the diagnosis. There was some discussion about the correct interpretation of that entry during the trial. The judge found that the paramedics had not seen the eyes rolling, but they were repeating what the mother told them she had seen. So that's quite important later on in this case. The judge expressly recorded Dr. Rush's evidence that children with this type of presentation were seen by her in A&E at least once a day and several times a night. So I can't see any reason to disbelieve that. It's accident and emergency. Children are coming in regularly. Dr. Rush has obviously asserted that there was nothing about the presentation that was out of the ordinary. Dr. Rush had said in her witness statement and repeated in evidence that if WAC had said that her child's eyes were not tracking or were uncoordinated, she would have recorded it, but that on its own is not a worrying sign. Rolling eyes can be voluntary. I would have taken it into consideration, but if her eyes were responding normally on examination, that would not have altered the subsequent management. The judge was concerned that the evidence may not have been adequately tested in cross-examination. Dr. Rush was called. The judge records that Miss Whipple, QC for the appellant, asked a number of questions, including the following. If you've been told FB's eyes were rolling and not coordinating that, together with the rest of the history, it's not very well written, this. If you had been told FB's eyes were rolling and not coordinating, that, together with the rest of history, should have led to a referral to paediatrics. Not even a question, but no. So, I mean, basically she's saying, look, based on what she was aware of and the fact that had she been told that the eyes were rolling, it shouldn't have automatically resulted in a referral to paediatrics. Whether that's so I want to clarify at this point, whether or not that's a fair opinion is hard for me to say. You'd have to get someone in here as a paediatrician to assess this. I think other things and other aspects of the case I can more readily comment on. That obviously requires someone who's examining a lot of children and so forth. The judge then asked her some questions. He records the exchange thus. Then in answer to my questions, Dr. Rush asked if the history given was of the child's eye rolling and being uncoordinated in the context of a high fever. She would have considered this might have been a febrile convulsion. Then she said that if there had been any hint of febrile convulsion, she would have referred the case to the paediatricians. She would not have spent time thinking about it. So that kind of qualifies what was commented in the previous page. This was a significant change in important evidence at a very late stage of the case. Later in his judgment, the judge said Dr. Rush was far too slow to accept what she would have done had she been told about the eyes rolling incident or had elicited it, but I put that down to inexperience with the forensic process and understandable defensiveness rather than to anything more concerning. This was a generous conclusion given the central importance of the evidence and the very late stage at which the change was made. FB looked well. At paragraph 106, the judge records, I am satisfied on the balance of probabilities that FB was at the very least exhibiting abnormal state variation when Dr. Rush examined her. More specifically, she probably was unusually quiet and passive. Notwithstanding the expert's view as to the likely presence of lethargy, the judge did not accept important parts of the parents' evidence, rating in particular to obvious lethargy at the time of Dr. Rush's examination. He therefore concluded that such signs as were there on the expert evidence were subtle and would need an experienced eye to pick them up. He relied on the observation of the defendant's causation expert, Dr. Ninnis, that the level of what you were trying to identify often needs a senior pair of eyeballs. Having recorded that Dr. Rush's note that FB looked well, was alert and active, and responsive to her surroundings, reflected her generally held professional view, the judge said, Dr. Ninnis did not say in terms that it would not be unacceptable practice for an SHO to fail to pick up this abnormal state variation, but that is the conclusion I draw from all the evidence I have heard. He therefore concluded that there had been no breach of duty in the way Dr. Rush carried out the examination of FB. So just to give a bit of commentary on this, what is essentially being stated is that the signs, the clinical signs, we've heard this mentioned in previous videos. Excuse me. The clinical signs for this infant are very subtle, and this is an inexperienced medic. So it's perfectly possible that this medic can miss these very subtle signs that are indicative of the problems that were later encountered. This kind of thing has been discussed in previous videos. Now, that seems to me to be a very fair assessment by the judge in this case, and a very fair opinion, very reasonable opinion. There is further discussion of this as the case unfolds. It's important for me to go over this before we get to Dr. Evans' contribution so that you understand the full context of this case. So next important bit is that in this 23rd paragraph of the judgment, it noted that at paragraph 167, the judge recorded the parents' evidence that they would have given this information if asked, and concluded, I have no doubt that they would have done, and they are not to be criticised in any way for failing to do so. The judge identified the issue for him to determine as whether it was substandard practice for an SHO in Dr. Rush's position to fail to obtain this information from the parents. Now, I don't want to be too harsh on these parents, but I believe that if you take a child to accident emergency for a specific reason and you notice an unnatural physical sign, the onus really is on you to communicate that to the doctor. I don't want to be too harsh on the parents because it's a stressful situation. They've been through something very difficult that's going to have life-changing consequences. It was very early in the morning, and I think it's important to know as well, not everyone has the same level of social confidence. So they may not, they may have been a bit overwhelmed by the whole situation. They might have felt intimidated by being in the room with a doctor. There's all manner of possibilities. Nevertheless, I do think it's reasonable to state that if you go to a doctor because of something, the onus is on you to communicate why you're there. The doctor will ask questions and will probe you to a certain extent, but you have to communicate and you have to explain to them why you're there, and you cannot leave that room without having done that. That would be my interpretation. I think that's a reasonable interpretation. But we'll see what happens in this court case as it unfolds. I should say that the original judgment just simply isn't available, or I couldn't find it. I searched for it, but this is an appeal judgment. Of course, Dr. Evans wouldn't have been in the original case. He's come in for the appeal, it would appear. I don't think he appeared in the original case, though it's difficult to corroborate that completely because the original verdict doesn't seem to be available. So in paragraph 24, it stated that the judge found this difficult. He said that the final point has proven to be the most troubling, namely whether Dr. Rush was negligent in failing to elicit the history of eye rolling being the immediate and direct prompt to the advent of this family to A&E at this particular time. So typically wordy thing that the judge has said here, but it's essentially the judge is asserting that Dr. Rush, the case originally rests on whether or not Dr. Rush was negligent in failing to extract from the parents that there had been eye rolling in the past, in the very recent past, before the infant was taken into the unit. Is it reasonable to say it's the doctor's responsibility to extract that information from the parents, or is that not reasonable? Now, in the original verdict, the judge concluded that Dr. Rush behaved responsibly and that the doctor in question did everything reasonable, particularly for someone of their experience, and that they couldn't be expected to elicit this history of eye rolling as it's described. Now, I think you can perhaps already guess what Dr. Evans does when he comes into this case, but we'll continue for the time being. Having referred back to some of the evidence and set out the respective arguments to which I shall return, the judge expressed his conclusion at paragraph 169. In my judgment, a consultant A&E doctor or paediatrician either would have picked up the abnormal state variation or embarked on a line of inquiry which was likely to have elicited Miss Whipple's coda, i.e. the information about the eye rolling episode which precipitated the emergency call. In particular, an experienced doctor would probably have said to the parents something along the lines of, "This child looks fine to me, how was she different earlier?" Now, please note here the information about the eye rolling episode which precipitated the emergency call. So the eye rolling, it immediately occurred prior to the emergency call, and this strongly implies that it was the reason for the emergency call. So it's therefore very difficult for me to understand why you wouldn't communicate that to the doctor. Moving on. Paragraph 26. He developed the conclusion further by reference to the fact that an experienced clinician acquires an armamentarium, that just simply means an armory, essentially, of diagnosis and inquisitive resources, part intuitive and part knowledge-based, which enable her or him to penetrate more deeply into any given situation. He concluded overall that it was not substandard practice for Dr. Rush to fail to elicit the relevant history. Now, as I say, I'm not a paediatrician, but I would tend to agree. We know there's pressure in accident and emergency. If someone brings a baby into your office, it's stated elsewhere in the evidence that Dr. Rust essentially asked an open question at the start: "Why are you here? What's the problem?" Which is naturally what you would expect. It's horrible for the parents what's happened, but there has to be an onus, surely, on the parents to communicate why they've brought the infant in and that the infant was eye rolling, particularly if that's not happening at the moment. Because if the doctor examines the infant and sees that the eyes aren't rolling, then how is she to know that this has occurred? I think it's a little unreasonable to expect that information to be extracted via kind of cross-examination. If they had half an hour per appointment, maybe, but we know damn well there's huge pressure on accident and emergency and the NHS generally and hospitals. And if the parents don't come in and say, "Look, we saw the eyes rolling and we're worried about it," then what you're supposed to do. All you can do is examine the infant and say, "Well, it looks okay, it looks fine. I would do this." And yes, possibly the Dr. Rush could have asked for more from the parents, but to me, to expect them to extract the information that they withheld, and then for the parents to sue the hospital for negligence, I would tend to endorse the judge's original verdict. I don't know if people are watching this who have medical knowledge. Maybe there's even paediatricians or neonatologists watching this. I don't know, but I don't know. Doctors aren't mind readers. I mean, yes, they can ask follow-up questions, but surely the onus is on the patient, and in this case, and the parents of the patient, to say, "Look, this is the situation." This is quite a technical paragraph. It's just noted that essentially, when a doctor doesn't exercise the degree of skill, it's the health trust that's liable, not the doctor. It's talking about technical aspects of criminal negligence, but I just thought I'd note that. Here, we get to the Dr. Evans bit. So I thought I'd just skip over that bit so we can discuss Dr. Evans. So we don't know if this is Dr. Dewi Evans, but here is what we do know. This is a case that should have been referred to paediatrics, so it's very strongly related to paediatrics as a specialty. And we know that Dr. Evans, even now, likes to describe himself as a consultant paediatrician. We know it's a very young child involved. We know Dr. Evans was an expert witness that had done a lot of cases. So that's what we've established so far. We're going to establish further details as this case unfolds. So this paragraph comments that Dr. Evans, an expert in emergency medicine, called on behalf of the appellant, was firm and consistent in his evidence that it was a breach of duty to fail to elicit the reason FB had been brought to hospital in the early hours. So we can see here immediately, firstly, the Dr. Evans in question is claiming to be an expert in emergency medicine. So we'll return to the paragraph in a second, but I just firstly want to show you that there's a significant overlap between emergency medicine and paediatrics. And in this case, this would be an example of, you could easily see this could be Dr. Dewi Evans being called in. I'm a paediatrician, I can comment on this. And to be fair, that's not an unfair assertion. He can comment on this. It is essentially a case related to paediatrics. It's a young child, it's his area of specialty. It's not unreasonable for him to be involved. So Dr. Evans accepted that the question Dr. Rush said she asked, "Why are you here?" was a reasonable opening gambit. Of course, it's a reasonable question. So we can't that can't be denied. But I'd want to know specifically why they presented then and try and find out why. Temperature of a few days isn't a reason to present in the early hours of the morning. The doctor is the trained individual who has to ascertain why a child is presenting in the early hours of the morning and what was the precipitant of that. What was the anxiety that caused them to be present that evening? It's essential history taking. So what I would like to draw your attention to here is that this is the kind of definitive black and white view that we've come to associate with Dr. Evans. So Dr. Evans, of course, we're not seeing everything from this case. We're only seeing selected comments. So we should take that into consideration. But we're seeing here, Dr. Evans doesn't say, he concedes that the opening question is reasonable, which obviously it is. But he doesn't say, well, one would expect the parents to explain why, seeing as they were asked why you're here. Dr. Evans doesn't say, there's just what I've just said. There's a lot of pressure in accident and emergency. They need to deal with patients quickly. It's reasonable to ask why someone is here and then respond to that. They could have asked some follow-up questions, and maybe there were some mistakes made. A more balanced view. There's no, as we've seen, as Lord Justice Jackson wrote in his criticism of Dr. Evans, there's no evidence here of any attempt to present a balanced view. It's just simply, the doctor was wrong, here's why she was wrong. And she should have done this. That's what I would have done. It's what we've come to expect from him. And I know we haven't established this with Dr. Dewi Evans, but already, in my view, we're already seeing a pattern of behaviour and evidence that could be associated with him. Putting the entire onus on the doctor as the trained individual who has to ascertain why the child is present in the early hours of the morning and what was the precipitant of that. What was the anxiety that caused them to be present that evening? It's essential history taking. Of course, that's true. I don't think anyone would reasonably deny that. But is it reasonable to expect them to drag that out of the parents? I don't know. For me, it's not really reasonable, because you're asking them why you're here, and then presumably the parents told Dr. Rush why they were there, and then Dr. Rush examined the infant and said, well, I can't see anything wrong, try doing this, and then they left. That must have been what happened. It's just, I don't think it's fair here of Dr. Evans to say he should have somehow dragged this opinion out of them, or dragged this symptom out of them. I can't see that that's reasonable. And of course, it's said here so definitively, as we've come to expect from this gentleman. So in the next paragraph, we see, in answer to questions from this court about whether there was any exploration in evidence or in submissions to the novel proposition that was a variable standard of care applicable to history taking in A&E depending on the seniority of the doctor, Ms. Gumbel referred us to the single passage in the transcript where it was raised. The judge asked Dr. Evans a number of questions directed to the standard of care. It is sufficient to refer only to the following exchange. My question was, does there come a stage where a doctor says to the parents, the child is looking well to me, is this how she has been over the recent period? That's a very reasonable way of assessing how the child is, and is the parent happy with the child? The judge went on to ask whether that was an answer he was giving as an experienced consultant, or is it an answer which you say as an SHO in Dr. Rush's position should have asked? Every A&E doctor, particularly a doctor with some paediatric experience, would know that the parental opinion is very important, and parental concern, and it's why have they brought that child into that department that night? What's worrying them? You have to home in on that. So I think this bears some analysis. Firstly, this question here, my question was, does there come a stage where a doctor says to the parents, the child is looking well to me, is this how she's been over the recent period? So that is something that could be said. Of course, that could be said. But Dr. Rust actually explains, I think we're going to see that among these pages, but Dr. Rust explains that her usual approach is to ask an open-ended question at the beginning of the consultation to give the patient the opportunity to explain the situation. Now that seems entirely reasonable. So then, obviously, once you've got that explanation, you then engage in a fact-finding mission from there. But you're surely reliant on what the parents explain to you, particularly if the condition. This is all about eye rolling. So if eye rolling wasn't present in the infant when the infant was in the accident and emergency unit, then the onus surely is on the parents to say, oh, by the way, the eyes, I can't remember if it's a his or a her, this infant, the infant's eyes were rolling, and that really concerned us. Surely the parents have to communicate that to the doctor. I don't see. Otherwise, every A&E appointment would be crazy because you'd be saying, right, why are you here? Okay, here's the reason. Okay, I was having the infant. The infant's fine. Now, are you sure? Are you sure that's the reason you're here? What else was happening? What's the recent history? The history taking, I would say, inherently is based on you asking these questions. The initial question, everyone's been in a doctor's surgery. They ask you what seems to be the problem, and then you tell them what the problem is. And then they ask you follow-up questions. That would be normal, surely. That's what every single doctor's appointment that I've ever experienced in my entire life has been like. And Dr. Rust actually explained in the judgment as well that it's quite common for infants to be presented, and there's nothing really wrong with them. It's just obviously parents get anxiety. That's understandable. It needs to be handled delicately and sensitively, but that doesn't mean there's anything wrong with their infant. And Dr. Rust noted as well that there were no clinical signs, and it's noted as well in the judgment that the clinical signs are subtle. Yet because Dr. Evans this is so indicative of this being Dr. Dewi Evans, because instead of taking all these things into consideration and offering a balanced view, he immediately comes down on the side that he's representing, which is the appellant side. So in this situation, instead of discussing all the things that I've just mentioned that I know as someone who isn't a paediatrician, and that pretty much anyone will know who's been in a doctor's surgery, he just immediately says, Dr. Rush is in the wrong, Dr. Rush should have done this. Every A&E doctor should do this. They would know that the parental opinion is very important and parental concern. Yeah, but I don't think no one would dispute that parental concern's important, and no one would dispute that parental opinion is important. They've obviously brought in their infant into the unit. The question would be, is it reasonable to expect the doctor in every single appointment to extract the reason that the person is there from the parent? I would say that it's not reasonable. So I've put a scenario here into ChatGPT. Now, of course, I will concede immediately this is not the ideal resource to use for this question, although the quality of answers you get out of this technology now is quite incredible. It would be better to consult with a doctor, naturally. But I'm going to read over this because I do think it's interesting, and it also raises several of the points that I just raised, which I didn't know it would do that. You never know what you're going to get out of this technology, and of course, I'm not a medic. I could be wrong easily. I'm just assessing it based on my knowledge and experience. So I've written here, consider the following scenario. A parent enters a doctor's surgery with an infant that they believe to be unwell. The doctor asks them an open-ended question about why they are there. The parent fails to mention a key symptom of illness in the infant. The doctor examines the infant and it is not present. The parent never mentions the symptom during the conversation and leaves without mentioning it. Is it then fair to blame the doctor for failing to extract the information regarding the symptom from the parent? In the scenario you've described, it would not be entirely fair to place full blame on the doctor, though it also depends on specific expectations of clinical practice, the nature of the symptom, and the overall context of the interaction. Here's a breakdown of the considerations. So please, before we go into all this, please note that it depends on the nature of the symptom. So the symptom was not present when this infant was presented. That's quite clear. If there was eye rolling, there's no doubt that the doctor would have noted this and would have acted accordingly, and there would have been some reference to it. So that's the first thing to know. Here's a breakdown of the considerations. Responsibility of the parent informant. The parent, as the person most familiar with the infant's recent behaviour and symptoms, has a key role in communicating concerns clearly. If they fail to mention a critical symptom, especially when given an open-ended opportunity to do so, they may bear part of the responsibility. Rule and duty of the doctor. A doctor has a professional duty to conduct a thorough history-taking process. Open-ended questions are just the start. They are typically followed by targeted closed-ended questions to ensure important symptoms aren't overlooked. Now that's an important point, and we'll return to that imminently. If the symptom is commonly associated with the presenting complaint or age group, then the doctor arguably should have specifically asked about it, regardless of whether the parent mentioned it. So that doesn't apply in this case at all. If the symptom was transient and not present during the visit, and not something the doctor could reasonably detect, the responsibility leans more towards the parent to report it. If it's something that is not easily noticeable without parental input, e.g. abnormal behaviour at home, vomiting episodes, doctors often rely on the parent's observations. Doctors are often under time pressure, and while not ideal, it may limit the depth of the history they can take. This does not absolve them, but it's part of the real-world context. Conclusion. The blame cannot fairly lie entirely with the doctor if they asked open-ended questions and were reasonably thorough in their examination and questioning. The symptom was not observable, and the parent failed to disclose it despite having the opportunity. However, if the symptom was something a prudent doctor would reasonably expect it to ask about in such a context, then they share in the responsibility. Would you let... Oh, sorry, that's of no relevance. So if we look back at everything that's written here, the first point is it's clear the parent must communicate the symptoms. That's obvious. And you don't want to be too hard on the parents who've been through a horrible experience, but they are ultimately suing the hospital for negligence. They lost their negligence claim, and now Dr. Evans is coming in trying to turn this around for them as an appeal. Obviously, he would claim to be an... I don't know if he would claim to be an expert witness, but it says quite clearly that he's appearing as part of the appeal, so I don't think he can really make that claim legitimately. So, this is a critical symptom. They've mentioned it in the ambulance. We know they've mentioned it in the ambulance. They didn't mention it, and that's not contested. It's known that they didn't mention it. It wasn't mentioned when they came into the office, and this infant wasn't presenting with those symptoms. So where it says here they may bear part of the responsibility, I feel they should bear more than part of it, but clearly it's not entirely the doctor's fault. That's obvious. Now, we're going to come on to these closed-ended questions because the original verdict concluded that Dr. Rush did ask closed-ended questions in addition to the open-ended question that was asked at the start. But I would say it's very, very difficult to... If someone comes into your surgery and they say, we're worried because our child seems unwell, if they can't give more... I doubt they made a clinical diagnosis of what was wrong. That's very unlikely, obviously. They just must have said, there's been some worrying signs, or we're worried about our daughter looks unwell, or she's a bit lethargic, or whatever. It's going to be very difficult. Doctors can do this. Doctors know a lot about the medical profession. They know a lot about various conditions, and sometimes they can pinpoint things down. When they ask the initial open-ended question, they're going through their memory banks of what they know about various conditions and trying to bring forth information that would help them to diagnose. They cannot be perfect in doing that because there are so many overlapping conditions with overlapping symptoms. It's just impossible. But if symptoms are withheld from them, it's going to be unbelievably difficult for them to make an accurate diagnosis in the time frame that they have. And I think expecting them to say, oh, by the way, was the infant's eyes rolling, without having been told this is a big ask, in my view. And as we see here, this symptom must have been transient because it wasn't present during the visit. It's not something the doctor could have detected, not even reasonably detected. They could not have detected it. Dr. Rush could not have detected it. So that in this case, the responsibility leans more towards the parent to report it. Entirely fair. So already we've seen in Dr. Evans' evidence, he never made any such statement. He must know this. If I know it, he definitely should know it. I mean, doctors are not mind readers. He thinks he could have stopped these alleged crimes on Lucy Letby's unit through just like immediately, just through his genius. But for normal people, that kind of thing isn't possible. And it's said here, if it's something that is not easily noticeable without parental input, doctors often rely on the patient's observations. So they're talking about abnormal behaviour at home. Well, eye rolling is abnormal, but if it's not communicated, they don't know about it. There aren't vomiting episodes. It's nothing like that. Eye rolling is quite subtle. And as we saw in the original verdict, it was explained that the clinical signs for this condition are very subtle. So how can the doctor be expected to pick up on them? Even a trained paediatrician may not pick up on them. They may have done a better job of interviewing the parent. They may have done a better job of dealing with the parent. They may even have picked up on these incredibly subtle clinical signs. But I say that even a very highly trained and very experienced paediatrician could miss out on a symptom if the parent walks into the office or their surgery and doesn't tell them about it, and it's not present when the infant is there. And then this point about time pressure that I raised myself. So I think it's hard to say. There's this comment about whether the doctor would share in the responsibility. For me, it's hard to say that the doctor in this case would share in the responsibility. But certainly we know that the doctor asked open-ended questions, and we know the symptom was not observable. We know the parent failed to disclose it. So it's undeniable that the blame cannot fairly lie entirely with the doctor. Whether it lays partly with the doctor is debatable. Whether it truly represents negligence is debatable. But the important thing to note is Dr. Evans hasn't conveyed any of this. Dr. Evans has just said, oh, the doctor should have done this. Any A&E doctor should have done that. And they should have known immediately. And this is part of history taking, is to extract this kind of information through like mind reading. Completely unreasonable, in my opinion. But we're going to go on to look at the remaining aspects of this verdict in more detail. So in the 36th paragraph of this verdict, I think is where we get a really big clue that this is Dr. Dewi Evans, and there's some really significant stuff in here. So this paragraph states, at paragraph 134, the judge found that I have no doubt but that Dr. Rush tried to elicit a full history from the parents and adopted her standard practice in asking an open facilitative question. She may well have asked follow-up questions. So it's very significant with regard to what we've just been looking at. Dr. Rush has essentially done what she always does in this situation, which is described by the judge here, that there's an open question at the start, and then it's likely that follow-up questions followed, as you would expect. It's pretty much exactly what you would expect. If you think about going to the doctor, that is almost always what happens. You don't go to the doctor and expect, right, the doctor's going to have to drag details out of me. It's just not something you would reasonably expect. He later pointed out that no expert had criticised her technique. True it is that no one criticised her for asking an open question to start the process, but Dr. Evans was, as I have already described, highly critical of her failure to ask a question or questions which elicited the reason the parents had brought FB to hospital in the early morning. So immediately I would say, is it reasonable to be highly critical, and is it reasonable to describe this as a failure? Is it? I don't think it is. But anyway, we're going to see some more significant information in a second. The judge recorded, as Dr. Evans put the matter, the SHO failed to ascertain the key issue of why the parents were in the A&E department at 5 o'clock. This was an essential facet of the history. Dr. Evans, so this is really the absolute key point here. Dr. Evans had written his report and given evidence in chief on the understanding that Dr. Rush has seen the ambulance record. When he learned that this was not the case, he remained of the view that Dr. Rush should have elicited the history. Now, I'm sure this doesn't need any explanation to anyone that's familiar with Dr. Evans by now, But we know Dr. Evans and his multiple reports. But here we go, Dr. Evans. So his original view was reasonable. So when he wrote his report and gave evidence on the understanding that Dr. Rush had seen the ambulance record, under those circumstances, his report and opinion would be entirely reasonable. Because in the ambulance, we know this woman told the ambulance driver that the eyes were rolling. It was recorded in the ambulance record. Had Dr. Rush seen that, it would have been, I think, a reasonable assumption. I mean, I would say it's definitely negligence because obviously you've got the ambulance record, you've got this unusual behaviour. They know a lot about pediatrics. They know a lot about what you should expect to see. I mean, I think anyone would say you don't expect to see eyes rolling, but obviously they would know the significance of this. That could be described as negligent. So he's made his initial opinion on that basis. Then he's learned that she never saw the ambulance record at all, but he's still just remained of the view that Dr. Rush should have elicited the history. Why has he remained of that view? Because, firstly, he's never wrong. He always has to be right about everything. So, firstly, he's put into this court case that, Dr. Rush should have done this and Dr. Rush should have done that. Well, actually, Dr. Evans, you never saw the ambulance record. Well, I'm still right anyway. That's the first reason. And the second, probably more compelling reason, is that Dr. Evans is acting on behalf of the appeal. So if he suddenly changes his opinion, he says, well, actually, I didn't realise that she hadn't seen the ambulance record. I mean, that changes the whole thing. Then he's not acting in favour of in support of the appellant anymore. And almost certainly the appeal will fail. Dr. Evans will lose a case. He'll get less work. He won't be able to boast about his record as much anymore, etc., etc. Obviously, he should have taken into account the fact that the doctor hadn't seen the ambulance record. That means that the doctor had no knowledge of the eye rolling incident when that parent and the patient walked into their surgery and into the office, however you want to describe it. That's a critical difference, because now it means that if the doctor wants to learn about that very critical symptom, there's only two possibilities. Either the parents tell the doctor, which is what you would expect to happen, or somehow the doctor is able to extract that from the parents. But you would usually, under any normal circumstances, you would expect the patient or the parents of the patient, because the parents are the only one that can communicate here, to convey the key symptoms and the key reason for being in the surgery to you directly, indeed at the very start of this discussion, which is why they ask an open-ended question at the start. Why else do they do it? The whole reason for asking an open-ended question is so that what seems to be the problem here? And then you say, right, well, I've been having leg pain, or my heart's been twitching a bit recently, or in this case, we're very concerned because our daughter's been lethargic, we saw her eyes roll, etc., etc. If that is not conveyed, then it's always going to be difficult for any doctor in any situation, regardless of whether it's pediatrics, could be general practice, whatever it is. If there are specific symptoms that are, it's like what percentage of infants will or parents that. I mean, for starters, it's accident emergency, so I don't know if it's all pediatrics or not. That's not entirely clear to me. It probably was, but I don't know. But anyway, what percentage of patients, regardless of if it's young children or not, what percentage of patients are taken into that surgery and they present as having eye rolling? I'd say it's a pretty small percentage. It could be 1 in 100, it could be 1 in 1,000. I don't know what it is, but it's going to be a small percentage. It's not a symptom that I've known lots of people with young children. I've never known them have a single incidence of eye rolling, ever. I'm sure it happens. I don't know what percentages. Maybe we could try and ascertain that in a second. But clearly, it's not something you wouldn't say, oh, by the way, were the symptoms of eye rolling? I don't think that's reasonable. I don't think it's realistic. I think you're reliant here. You've got, as we've noted in the previous investigation from ChatGPT, you're under time pressure as well. So you've got to get as much as you can out of the parents in the shortest amount of time possible. And the best way to do that is just ask them what's wrong and then do an examination based on that information. Yes, you can ask them follow-up questions, and you see here the judge has stated she may well have asked follow-up questions. I would say it's basically inevitable that she did ask follow-up questions. And then, you examine the infant and proceed on the basis. Remember that in the original judgment, Dr. Ruster said we saw infants all the time, every day, numerous times, that have symptoms or that are presented in the same way as this infant. So, I mean, I think the original judgment is just simply correct, and it's only what is key to note is that it's only the introduction of evidence from Dr. Evans that has um, altered the outcome of this case. That's clear as we look through the judgment, as we'll continue to do, but also that completely convinced the judge. I don't know how, but in this circumstance, the evidence that he brought, like he said, "Oh, the doctor definitely should have done this. Anyone in A&E would have done that. They're completely in the wrong," and that he maintained that opinion even after the evidence changed. So, I think originally that was an entirely reasonable view. I think once we know that Dr. Rush never saw the ambulance record, it becomes an unreasonable view. The judge said Dr. Evans' evidence proceeds along a path of reasoning that I cannot accept. Because there is no reason for the parents failing to detail this evidence, Dr. Evans says it follows that there was a failure to elicit it. That, in my view, involves a non sequitur. I agree with that completely. In this judgment that Lady Thirlwall contributed to, it is stated, "This is puzzling." The judge observed in several parts of the judgment, including at the end of paragraph 169, that there was a failure to elicit the reason prompt precipitant for FB's parents to bring her to the hospital at that time. There could be no doubt about that. The question was whether that failure was a breach of duty. The judge had accepted that the parents would not have given the information if asked. It followed, therefore, that they were not asked. I just don't. I mean, I find that such a strange statement because I can't understand why you're turning this verdict around. You just cannot expect a doctor to as I say, I've used this phrase several times, to drag information out of parents. I mean, why are the parents walking out of this surgery? They've gone there for this reason. They've told the ambulance staff, but then they haven't told the doctor, and then they're walking out without having told them. And then they're saying that's negligence on behalf of the doctor, and the doctor should have somehow dragged this information out of us. I just can't understand it. I cannot understand how the judges overturned this judgment. It's absolutely ridiculous, in my view. I mean, I'd be interested to get the opinion of medical experts. Maybe this Dr. Rush could have done a better job. I don't think the omissions that we've seen in the evidence here meet the standard of medical negligence, personally. So I'm not going to comment on this paragraph too much, but I just wanted to read it. So what Dr. McConaughey's evidence and the respondent's defence came to was that Dr. Rush had elicited a history from which, in conjunction with her examination, she could make a diagnosis which fitted with the most common diagnosis. Despite persistent cross-examination, Dr. McConaughey never directly addressed the fact that given that Dr. Rush had not elicited the precipitant, she had not obtained the history of this child. As the judge observed, he had also failed in his written report to deal with the question of the failure to elicit the information. That was a significant omission in the light of the evidence of Dr. Evans. So I don't want to comment on that too much. It's a kind of technical argument arguing that Dr. Rush has not successfully elicited the history. The next paragraph is much more significant. This is paragraph 41. The judge records that Dr. Rush told the court, "Usually, if there are rolling eyes, that is scary. I wouldn't need to ask the right question, the parents would tell me first of all. In all my years in accident and emergency as a GP subsequently, you don't need to ask the question." Now, I don't see how anyone could possibly disagree with that. Obviously, Dr. Evans did, because he was required to do so because he was with the appellant. But again, in the original judgment, I understand why the judges said we shouldn't be critical of the parents, or one doesn't wish to say unpleasant things or insensitive things about parents that have suffered something that must be very, very disturbing to them. But like personally, for me, if I went to a surgery, I didn't communicate the reason that I'd gone there, and I walked out without having doing so, and then there were consequences. Those consequences would be on my head, and I would not think, well, it was the other person's fault. That's just how I feel about it. Dr. Rush seemed to be unaware or had excluded from her consideration that the parents in this case had observed the frightening eye-rolling episode but had not told her about it. What does that even mean? What does that even mean? It doesn't even mean anything. She seemed to be unaware or had excluded from her consideration that the parents in this case had observed the frightening eye-rolling episode but had not told her about it. What does that even mean? It doesn't even mean anything. More importantly, she could not know how often the parent had not volunteered information. I mean, this is like so that particular sentence. This is like there's a famous. I've forgotten the name of the guy from the U.S. government. He's a black guy, I believe. It's not Dick Cheney. It's one of the others from the neocons. But there's a famous comment around the time of the War of Terror, around the Iraq War, and all that about known knowns and known unknowns and unknown unknowns. I've forgotten who made this statement. I don't think it was Dick Cheney. So what the judge is arguing here is that you don't know how often people have told you haven't told you things. So basically what the judge is essentially arguing is you can't, as a doctor, you cannot assess what is normal behaviour because there's things that you can't ever know, which is a bizarre argument. It's a typical legal argument in that it's just utter rubbish, but there you go. The judge considered that she was really expressing an opinion, admittedly one based on her experience of human nature and her practice as a doctor. So you would think, not unreasonably, that if someone offered an opinion that is based on experience of human nature and a practice as a doctor, and you're talking about medical matters, that would be considered, more reasonable in the view of a judge, but obviously not. By definition, however, she cannot know the number of occasions on which patients, for whatever reason, have omitted to give a full history. I mean, this evidence does not feature in the judge's analysis of whether the doctor's history taking was substandard. An approach predicated on a mistaken belief that there are some things that do not need to be asked about is plainly flawed. I mean, I just consider this to be absolutely ridiculous. It's a statement that is prosaically obvious that if there are significant symptoms in a patient, that would usually be communicated openly to the doctor. That would happen in the vast majority of circumstances. Eye rolling is, as the doctor rightly notes, scary, and it cannot the onus cannot be on the doctor to extract that information from the patient. And you can't start making these like sophistic arguments about, oh well, just because she has some experience of human nature, she can't ever know how many times someone have come into surgery and not explain key symptoms. But we can reasonably assume most of the time that parents come in with their children and there's a key symptom, they tell you about the key symptom. Surely we can assume that is the case. You can't start making arguments about, oh, we don't know how often this will happen. It's just quackery. It's nonsense. And I could go on about this for a long time, but I'll just move on to the next paragraph. The judge foreshadowed his conclusion at paragraph 168. He placed significant weight on the evidence of Dr. McConaughey about the fact that parents may attend A&E at all hours of the day and night without there being any direct and obvious precipitating factor. He said, in my judgment, it is incorrect in this sort of situation to subject human nature and behaviour to an overly rigorous and inordinately logical analysis. Although we know that there was in fact a clear precipitating factor, human nature is such that there often does not have to be. He went on to reject the evidence of Dr. Evans and the submissions of counsel for the appellant on the grounds that they have a tendency towards circularity and to rely on hindsight. I entirely agree with that decision. We're seeing the same pattern here with the evidence of Dr. Evans that, essentially what has happened here is the judge has rejected the evidence of Dr. Evans and the submission of the counsel for appeal because it's demonstrating the same pattern that we've seen from Dr. Evans, this pattern of attempting to work out a conclusion that fits the case that he's trying to argue, rather than doing what he should do, which is say it's entirely reasonable what has occurred in this case, and that the original verdict is entirely reasonable. I mean, if you, I don't quite know. I assume he's there to be an expert witness. I assume he's supposed to be bound by all the conventions that have been discussed in regards to the Letby case with regards to impartiality. An impartial assessment of this situation is that the doctor behaved entirely reasonably and the onus was on the parents to communicate the symptoms and that normally this is what would occur. I can't believe any other conclusion is rational even. There the judge fell into error. The fact that there is no clear precipitating factor in many cases is not an answer to a failure to elicit such a factor when there is one. That is the fundamental purpose of history taking. The fact that most children who are brought to A&E are not really unwell is not an answer to a failure to elicit the information which leads to the identification of the unwell child, particularly where, as here, the parents are willing to give the information. So I want to examine a few aspects of this paragraph and put this into proper context. So bear in mind, the parents walk in, they don't give the information. The doctor asks them an open-ended question. They don't give the information. It's acknowledged in the original judgment that the doctor asks follow-up questions, which is obviously what you would expect to happen. The doctor examines the infant all the time. They can give this information of eye rolling. We know the doctor hasn't seen the ambulance records, but here the judgment and the verdict is still saying that somehow history taking is about eliciting factors from parents and patients by some kind of process of cross examination. Um, that just strikes me as logistically impossible because there are so many symptoms that could occur in any child under any circumstances. It's all very well and good for us to sit here as non-medics and say, oh, this person should have known this, and they should have known what condition it was, and they should have worked this out, and they should have worked that out. They've got 5 minutes maybe, or a very short period of time. They've never met this person before. They don't know what's happened to the infant. They don't know what the presentation is going to be. They're going to come into their office, and it could be absolutely anything under the sun. They could have, just grazed their leg, and it could be like a simple matter of administering some simple treatment to that, or it could be very serious. You just got no idea what it's going to be. You're so reliant. Yes, I accept that in history taking you're supposed to ask questions. I'm sure that is exactly what happened in this situation, and it's pretty incredible that this is in my view, it's incredible this is a medical negligence claim, let alone that the original verdict is being overturned because of Dr. Evans' evidence that he made on the basis of one set of information, but then when that information turned out to be completely incorrect, he just maintained his original view anyway because that's what he was required to do. There is nothing overly rigorous or inordinately logical about the proposition that is for an A&E doctor, absent special features such as drunkenness, refusal to comply, etc., none of which apply here, to elicit the reason for a child being brought to A&E in the early hours of the morning. On the contrary, this is the basic requirement of the history taker. So it's suggested, again, the judges are leaning on this idea that the job of an A&E doctor is to elicit the reason for a child being brought to A&E in the first place, in the early hours of the morning in this case. Of course, that is reasonable. But what isn't being taken into consideration by the appeal process is that eliciting that reason requires input from the parents. And that if the parents aren't going to give input and the parents aren't going to mention the specific reason, then requiring the doctor to always find out the reason under all circumstances is preposterous. Is impossible. Even if you had an infinite time frame, it'd be very difficult. But given that you have a few minutes and you need to deal with the situation quickly, you need to, you're asking the parents, tell me why this child is here, and then you ask the follow-up questions and you examine the child. This is exactly what happened. It's exactly what you would expect to happen. So moving on to the next paragraph, it's stated here, the judge had already found that Dr. Russ genuinely held view was that this child was alert, active and well, etc. As Jackson LG observed during submissions, in those circumstances it might be thought obvious to seek to establish what had caused the parents to bring her to hospital in the early hours. Dr. Evans had given evidence to that effect. So with regards to this, what I would like to state is that the doctor here believes this child is relatively okay. Obviously, they've heard some kind of generic information. Oh, we're worried. The child seems lethargic. So they examine the child. The child doesn't seem significantly unwell. The judge here observes that during submission in those circumstances, it might be thought obvious to seek to establish what had caused the parents to bring her to hospital in the early hours. Now, that's not an entirely unreasonable statement, but what I would say with regard to that is that what the doctor is trying to avoid is saying, why on earth have you brought this infant into the A&E? There's nothing wrong with it. What the hell are you doing? Obviously you'd put it more delicately than that, but you're trying not to put blame on the parents. You're trying to take their concerns seriously and do a medical investigation examination. You obviously ask questions, and as has been observed, they've asked the open-ended question and then the follow-up questions. You're not there. You're not there to kind of judge the parents for bringing them in. Obviously, Dr. Evans immediately says, "Oh well, he should have done this. He should have done that. She should have done this. She should have done that. That's what I would have done. I would have got it right. Obviously, I'm Dr. Evans." I I think there's a lack of empathy towards the doctor here. The doctors, trying their best, we know these are challenging circumstances, and the last thing the doctor wants to do is make the parents feel bad. And not only that, but you generally don't want to discourage people from bringing their infants into an accident emergency if you think that if they think there could be a reason, because that could be the difference between life or death. You don't want to dissuade people and say, well, don't bring them in because you're wasting our time. We're a busy department. We've got a lot of people here. There's nothing wrong with this child. The process that's taken place here, we can tease this out from the evidence that was in court and the evidence in this appeal. The process that's taken place here is perfectly normal. It's perfectly natural. The judge followed the same line of reasoning and identified a question which would have elicited the history. I hope I fairly described the question as entirely obvious. Unlike the examination where the judge considered, in light of the evidence of Dr. Ninnis, that the ability to pick up subtle signs comes with experience, there was no evidence that the need for a question like the one posed by the judge would be apparently only to a consultant. Dr. Evans' evidence, which was unchallenged, was to the contrary effect. No one suggested that the question or something like it was beyond the competence of an SHO. If the question should have been asked by a consultant, and I do not doubt that it should have been asked by an SHO. So this is just a technical argument. In the original trial, there has been the suggestion that because Dr. Rushed is inexperienced, kind of like at the level of a registrar, the same expectations can't be made of her as would have been made of a consultant. What I would argue is that this could easily have happened with a consultant. I can't see anything that indicates that the doctor has done anything wrong or that has behaved in a way that is unusual. The judge is expecting this doctor to go to firstly recognise very subtle clinical signs. Now we know from the Letby case, very subtle clinical signs can be missed. They're also expecting them to guess what the condition is and then drag the symptoms out of the parents via like a process of cross-examination, essentially. I just don't think that's reasonable. It is inescapable that Dr. Rush did not elicit why the parents had brought FB to hospital in the early hours of the morning. This was probably the result of a flawed approach to history taking. First, she believed wrongly that where a parent has witnessed something frightening, it is not necessary to elicit it, it is always volunteered. She didn't actually say that, but we'll come back to that in a second. Second, having formed the view that the child was well, and knowing that most children brought to A&E are in fact well, either she did not think about it or she did not consider it necessary to establish why FB had been brought to hospital at that time. As a result, she did not ask the judge's obvious question or anything like it. So the first thing is she didn't say it's not necessary. She said in most circumstances the parents will explain the key symptoms. She didn't say that always happens or it happens universally. I think it happens virtually universally. In fact, you'd expect it to happen universally, but she didn't say that. She said it happens most of the time or virtually all of the time. So usually it shouldn't be necessary to elicit the response, as is described here. And then the second paragraph talks about the judge asking an obvious question, but it's very difficult for the legal process to judge or assess this. I mean, essentially, this child has been brought in. They've asked a variety of questions with the initial open-ended question that is entirely reasonable. They've tried to elicit symptoms. They've examined the infant. I don't see how a legal professional can deem a question to be obvious in these circumstances or assess whether or not the subtle signs of presentation with regards to this condition should have been noticed. I don't see any way they could possibly assess this, but on the basis of what we know about this case, I can't see what the doctor realistically could have done differently. And even if they could have done things slightly differently, I don't think that should amount to medical negligence, and I think the original verdict's absolutely correct. It really is just simply this judge, primarily Lady Thirlwall, although others are involved as well, so I don't know the chain of command, but there are more than one judge involved in this case, but Lady Thirlwall's been involved in it. They've been convinced by the evidence of Dr. Evans, which didn't change after the circumstances changed, and he has been very dogmatic in his view that the paediatrician, the person in accident emergency, this case it's a registrar level doctor, they should have been able to elicit this information definitively, 100%. It's his usual definitive statement. Anyone in this situation should have been able to do that and should have done it, and that's a critical aspect of history taking. Whereas I would argue that what he has stated there in court is completely unreasonable, and it's based on the initial information that the ambulance record was available. As soon as the ambulance record is not available and the parents don't communicate this key symptom, this could easily happen to any doctor, in my estimation. So I'm going to finish this section by just reading out the judgment without commentary. So in my judgment, the conclusion that the history taking was not carried out to the standard to be expected of a competent SHO is inevitable. In the light of my conclusion on the history taking, I am satisfied that Dr. Rush was in breach of duty and negligence as established. I do not consider it necessary to deal with any other grounds. I would allow this appeal. Lady Justice King. I have had the advantage of reading in draft the judgments of Jackson LJ and Thirlwall LJ. I agree with them. I would allow this appeal. I agree with Thirlwall LJ that history taking is a basic skill which hospital doctors at all levels are expected to possess. Now, I will just comment on this. The doctor has engaged in history taking. It's just that the legal system here is requiring a level of history taking from the doctor that I think is unreasonable. And I think the original verdict is just simply correct. The fact that FB's eyes had been rolling and uncoordinated was the event that precipitated the hospital visit. The ambulance staff picked this up. They picked this up because they were told. I'm damn sure the ambulance staff didn't pick this up. They either saw it when it was in the ambulance, or they were told. That's why they recorded it. There's no way that they cross-examined the parents and dragged the information out of them. I just cannot. There's no evidence for that anyway. It's very unlikely that that's the case. And so clearly, maybe the ambulance record should have been passed on, or if the ambulance records weren't passed on, the parents should have passed this on to the doctor. I do not, excuse me, I do not accept the judge's conclusion that only a doctor more senior than Dr. Rush can reasonably have been expected to elicit this important fact. Therefore, the judge's decision cannot stand. So I think what the original judge was saying was that a more experienced paediatrician, for example, may have picked up on these incredibly subtle signs that are very difficult, that do require experience. So I'm speaking to people all the time, and have spoken to lots of people that, have worked on neonatal units, they've worked with paediatrics, young children, and they'll say, look, experience is critical because there's so many different things that can happen. It's easy for us to sit here as non-medics and just say, oh, they should have worked this out, they should have worked that out, but it's not easy. And if they make the wrong decision, that's disastrous. So not only are they trying to, I think it's important to understand, not only are doctors trying to get to the right diagnosis, they're trying to avoid jumping to incorrect conclusions and going down a pathway that is dangerous. And that's perhaps something that the judges haven't taken into consideration here. I do think the original conclusion, so I think they're essentially confused by the original conclusion. So the idea that Dr. Rush can reasonably, it's to do with the experience of the doctor. I think their point is fair on that point. If you're there in accident emergency, you're being trusted to do it, then you should be expected to perform competently. I agree with that. But what the judge is perhaps missing, or the judges have missed, is that experience is a critical aspect. And in a very subtle presentation, experience can make all the difference. And then on top of that, even with experience, an incorrect diagnosis can be made, particularly if the parents or the patient do not communicate the key symptoms that they've observed. So paragraph 65, before parting with this case, I must acknowledge that junior hospital doctors work long hours under considerable pressure. They are often involved in life and death decisions. The pressures can be even greater when they are working all night, as Dr. Rush was here. If mistakes are made, it is devastating for the patient and is expensive for the NHS Trust. Doctors, however, are human. Even good and conscientious doctors may from time to time fall short. That is not a reason to lose heart or to abandon medical practice. Those who have learned from past mistakes often have even more to offer. It's a very fair comment. What I would state with regard to this context is that I'm not really convinced there were any mistakes made here. Or if they were, I don't think they were significant enough to constitute medical negligence. So one final thing that I'd like to mention with regard to this is that I did a bit of research to see if I could find out any more information about it. I was more looking for the original judgment than anything else, and I encountered this case note that was written by Philippa Kemp. So here it states that Philippa Kemp is associated with Liverpool Law School, School of Law and Social Justice from the University of Liverpool. She's now a law lecturer at Oxford University. And unfortunately, I can't get the whole document for this, but that may be a good thing because then this video could go on for 3 hours. So I might get the judgment one day and do a separate video. The problem is that it's very difficult to get hold of these legal documents, and It is on Amazon India, but it costs £450. I'll try and get it, maybe, at some point, we'll see. But the point is that she's very critical of this judgment. In a recent case of appeal against Princess Alexandra Hospital NHS Trust, the Court of Appeal was wrong to find that Dr. Rush breached the standard of care for taking a history in FB versus Princess Alexandra Hospital NHS Trust. An analysis of the court's judgment shows that the court has failed to test the standard of care for taking a history against the measure of reasonableness. The application of the measure of reasonableness demonstrates that Dr. Rush did provide a reasonable standard of care. Although the court was right to uphold Wiltshire versus Essex, because junior doctors should not be held to a lower standard, this does not justify the Court of Appeal setting the standard of care higher than is expected by a reasonable standard. To uphold this precedent places an onerous burden on GPs. Now, I almost entirely agree with everything that is stated there. In fact, I think I literally agree with everything. It's pretty much all the points that I've made when I was analysing this. So the first thing is just recount. The first sentences are just recounting what has occurred. An analysis of the court's judgment shows that the court has failed to test the standard of care for taking a history against the measure of reasonableness. I mean, I entirely agree with that. I think the standards that have been set in this appeal document are unreasonable. The application of the measure of reasonableness demonstrates that Dr. Rush did provide a reasonable standard of care. I agree with that. I think she behaved conscientiously, and I think it's completely wrong that her actions have now been viewed as being medically negligent, primarily because of the evidence of Dr. Evans. As I said, I think originally, if she'd had the ambulance record, then it would have been negligent. But as she didn't have the ambulance record, but Dr. Evans still maintained his opinion anyway, I think it's completely unreasonable to say that she didn't give a good standard of care. So I can't really comment on this Wiltshire versus Essex thing. Oh yeah, it's just about junior doctors not being held to a lower standard. Completely agree with that. I just argued that previously. If you're in the accident emergency ward and you're seeing patients, you've got to be held to the same or a very similar standard as any doctor. It's absolutely true. Nonetheless, this does not justify the Court of Appeals setting the standard of care higher than is expected by a reasonable standard. Agreed. To uphold this precedent places an onerous burden on GPs. I agree completely. I think it's completely unreasonable, and any doctor in that circumstance is going to find them, if they're required to drag conditions out of the patient every single time a parent or patient walks into the office or surgery, it's going to be phenomenally difficult for them. And this judgment establishes a precedent that that is what they're required to do. And if they don't mind read the parents or the patients and work and then engage in some incredible process, like sort of Darren Brown type process where they manage to work out what the symptoms are, then they're negligent, is ridiculous. And it's important to emphasise once more, this has happened entirely because of Dr. Evans. So finally, I'm going to summarise this video. Lady Justice Thirlwall presided over a case involving medical negligence in May 2017. The case also involved a Lord Justice Jackson, but it does not appear to be the Lord Justice Jackson who wrote to the Letby trial judge James Goss. The case centres around whether or not a medic was negligent in failing to elicit an explanation from parents for why they believed their young child to be unwell. The grey areas in this case are quite apparent, as the original defence of Dr. Rush, accused of negligence, does not appear unreasonable. It does also seem curious that parents would take the child to A&E and leave without having explained why. Nonetheless, it equally seems fair to state that one would reasonably expect the medic in this situation to ensure that they understood precisely why this child was being presented. In mitigation, one would generally expect the parents to state this when asked an open-ended question at the very beginning of the conversation. In my unprofessional opinion, this is a nuanced situation, but I do have sympathy with the medic considering the inevitable pressure that they were dealing with, the reality that this occurred in the very early hours of the morning, the record which indicates that they did behave within the reasonable parameters of what one would expect, and the fact that the original judgment went in her favour. I don't wish to be unduly critical, but I will say this: if I took a child to A&E, left without explaining why, and there were consequences, I would blame myself, not the hospital. In mitigation, I acknowledge that people have differing levels of social confidence, particularly in stressful situations. A Dr. Evans appeared in this case as an expert in emergency medicine. Dr. Evans was called on behalf of the appellant, and so it would be hard to claim that Dr. Evans appeared in a neutral capacity. Dr. Evans gave evidence which contradicted the original verdict and which was instrumental in the appeal being upheld in favour of the appellant. An assessment of this case written by an Oxford University law lecturer was later critical of the verdict. I entirely endorse the view of this lecturer. I cannot definitively state that this was Lady Thirlwall and Dr. Evans appearing in the same court case, and Lady Thirlwall essentially finding in his favour 2 months before Dr. Evans made himself available to Cheshire Police, with the verdict for this case being in literally the same month, as I cannot confirm beyond all doubt that this was Dr. Dewi Evans. But there is a lot of evidence that points to this, such as the following. This case involved a young child, and as a paediatrician, Dr. Dewi Evans specialised in this field. There is known overlap between emergency medicine and paediatrics. Let's be frank, Dr. Evans is likely to put himself forward as an expert in almost anything. We see in this case a similar pattern that we've come to expect from Dr. Dewi Evans, very definitive black and white statements that are, coincidentally, consistent with the position of the appellant, who has called him to give evidence. Furthermore, even when the circumstances of the case change critically, the opinion of Dr. Evans remains the same. Coincidentally, his opinion remains what is required for the party that has been called by to win the case. It is notable that the appellant was successful. Naturally, Dr. Dewi Evans would not lose a case, as he's only too keen to inform us. There aren't a huge number of expert witnesses that can be called to a court case. Thus, even though Evans is a common surname, it seems fairly unlikely that this is a different Dr. Evans, considering all of the palpable similarities with Dr. Dewi Evans. Had the doctor in the case seen the ambulance notes in which the key symptom was mentioned, then the initial opinion of Dr. Evans would be entirely reasonable. The problem is that Dr. Evans has maintained his opinion after the material facts of the case change, and these have been expressed in a way that is dogmatic without any context of mitigating testimony. One can easily imagine that if he had been called by the opposing side, that he would have given the opposing view. It should also be noted that someone who knows far more about the law than me, who is certainly credentialed, has been quite strongly critical of the verdicts in this case, which is largely predicated on the evidence of Dr. Evans. It seems fair to assert that the judges, including Lady Justice Thirlwall, have failed to understand what could be reasonably expected of a doctor in these circumstances. Finally, I must concede that it is impossible to definitively state that this is Dr. Dewi Evans. I believe that this is highly likely, but I cannot confirm the identity of Dr. Evans. If it was Dr. Dewi Evans, which seems impossible to corroborate, this was almost certainly the last case that he worked on before beginning the Letby case. So, it's quite an interesting case, which is why I've taken time to look at it. Initially, this was going to be a short video, but then I realised that it needed proper analysis. I do think it's extremely likely that this is Dr. Dewi Evans in this case. If it is Dr. Dewi Evans, he is demonstrating the pattern that we've seen from him in other cases, where he has a definitive opinion. It's the opinion that he's required to support the side that he's been called by. It doesn't change when the material facts of the case change. And it's dogmatic, and it's not nuanced in any way, and it doesn't take into account any mitigating circumstances. It's just black and white. This is the case. This is 100% the case. That's all there is to it. And as I say, the fact that it doesn't change when the facts change is a massive clue, in my opinion. If anyone could either confirm that this is definitely Dr. Dewi Evans, or send me this document that's written by this law professor from Liverpool. She's a law lecturer now at Oxford University. She was previously affiliated with Liverpool University. But I think that summary is an excellent summary of this case that I completely agree with, and I'm sure the whole document is very interesting. If anyone could get hold of that and send it to me, then I would definitely look at it and probably make a video about it, maybe a shorter one. I'll try to get hold of it as well. But I thought this was really interesting because of the people involved, because of the timing, because of the behaviour that we see in it. It's all the same pattern. So now we know there's at least 4. I've got another case with Dr. Evans as well that I'll be looking at. But we've got 4 cases now. There's the case in which Lord Justice Jackson described Dr. Evans as worthless. There's a case in Northern Ireland where we see exactly the same behaviour and another judge being critical of him. There's the Letby case in which he's been roundly criticised for his conduct. This case is not as bad as those cases, but we see this exactly the same pattern of very dogmatic insistence that what I'm going to present before the court is 100% correct. There can't possibly be any other possible view. And it's something that will result in him winning the case, which he does. Now, credit to him, he's good at what he does. He's just not good at doing what an expert witness is actually supposed to do, which is give impartial evidence. And I think, I do believe that everything he's ever done should be re-examined. If you examine something like this is a relatively minor incident, I suppose, and also it's not minor for the parents, of course, but I just don't think there was medical negligence here, and I think his role in it again is regrettable, assuming that it is Dr. Dewi Evans. But I think whoever the Dr. Evans was gave evidence that is unreasonable. I think that I would stand by that view. It'd be interesting to know if there are any doctors watching this and if they have an opinion. As I say, my opinion is endorsed by this law lecturer, and I completely agree with what she's saying. And I've tried to be as reasonable as I can and analyse this as fairly as possible. And I just think that Dr. Evans that appears in this case has given evidence that is completely unreasonable. It would have been reasonable if the doctor had seen the ambulance notes. That would have been a big blunder. But as they didn't see the ambulance notes, I think their conduct was absolutely reasonable and up to a standard of reasonable care and professional competence. So that's the end of this video. Really appreciate all the support again. I'll just ask people briefly if you see this video and you haven't subscribed, if you could subscribe. It really helps. It helps more people see the video. It helps the YouTube algorithms. It'd be very much appreciated. I had a significant jump in subscribers after I mentioned this at the end of the last video, so I'm just mentioning it again. Thanks for all the support. And if you have any queries, comments, questions, corrections, as always, please do leave them. And I look forward to reading your responses.